normally what I will do is to say, I don't want to put this person in jail. I don't want to rip this child away this second. But if they're not going to cooperate with any of the therapy, this is what the law permits me to do. So if we have to have a hearing, we will have it. And I'll go into this later. A lot of the courts don't want to do a hearing, not surprisingly. If there is a trial, my focus on the trial is primarily how the alienation adversely affects the psychological well-being of the child. That is the important part of this. I say that when courts fail to act robustly and courageously early on in the process, there is a much greater likelihood of poor outcomes, and poor outcomes frequently occur when courts do nothing, fail to enforce parenting orders, or are too slow to act and allow children to continue to be exposed to the alienator and to the parental alienation without any contact with a good, loving parent over a long period of time. And that happens oftentimes. So as Linda had mentioned, and I will agree with her, time is not on the side of the child and the alienator, but because of the way that the court system operates, the family court system operates, this is what they do, and oftentimes it makes the alienation worse and worse and worse. And what I say is courts that do act robustly and courageously and do something such as removing a child, they should, the status quo should never be resumed, perhaps never, but certainly should not be resumed unless the alienator can demonstrate insight into their own thinking and behaviors and a willingness to voluntarily comply with court orders. Most of the alienators have very poor insight and judgment into what they are doing. And unless they are able to demonstrate that insight, they have to be kept on a very, very short leash because they're just not getting it. And they're going to go back to doing the alienation first chance they can get.